Hello, Washington Realtors. I'm Jeff Smart, your Washington Realtors president for 2024, and I'm here with Annie Fitzsimmons, our legal hotline attorney. And we have a kind of a funny topic today, but it's not really a funny subject. The topic is how to not get paid in real estate.
Yeah, and it's not funny at all to the, I don't know how many hundreds probably of buyer brokers across the state who have worked really hard in a transaction. They've represented well a buyer who is succeeding in purchasing property, and the buyer broker is not getting paid.
That's correct. And there are two very obvious ways that the buyer broker will not get paid after spending all that time and energy getting their buyer to the finish line and closing on that home.
Yeah.
And the first one is one we've been talking about quite a bit, and that's line 17 on the PSA, 17B.
That's right. So quick refresher, Form 21, Purchase and Sale Agreement, revised effective August 2024. Paragraph 17 has two blanks side by side. The first blank, 17A, is a blank where you have to identify the amount of compensation that seller has offered, if any. And then 17B is the contract, where you as the buyer broker create a contract term for the seller to pay compensation to the buyer broker. It's a contract between buyer and seller. Buyer and seller are going to agree that seller is paying compensation to buyer broker. But buyer broker, if you leave 17B blank, you are not getting paid by the seller.
Right, because the seller has not agreed to pay you or to pay your brokerage.
That's right.
So, and we are seeing that out there. I do see contracts coming through my office where 17B is blank. And so escrow is being instructed to not make funds available to the brokerage.
Yeah, and as a hotline lawyer, I've seen it, of course, in hotline calls. I've received calls from lawyers who represent sellers who want to know if they're reading the contract right. Is it really true that their seller doesn't owe compensation? I'm hearing from buyer brokers in a panic because they're not going to get paid. I'm hearing from listing brokers who are receiving offers with 17B blank, like you described, trying to figure out what to do with this offer now that buyer broker has disclosed that sellers offered compensation but didn't ask for compensation to be paid to buyer broker. And then as recently as yesterday, I heard from an escrow officer who has a Form 21 17B blank, but received a demand from buyer broker for seller to pay buyer broker compensation.
Right.
And so, Jeff, the purpose of this video is to drive home the message. I've made videos about this before. I figure if I bring in the big guns, if the president of the association says it, then maybe brokers will start listening.
Yeah.
It can't be said enough.
It's got to be filled in, period.
Paragraph 17B on Form 21 must have a number in it if you as the buyer broker want seller to pay your compensation. It's irrelevant that seller may have offered compensation. 17A is the disclosure only. 17B is the contract. If you don't fill in 17B, you are not getting paid by seller at closing.
Now, 17B is only one way that the buyer brokerage is not being compensated. There is another way that is happening as well, and that is a missing buyer brokerage services agreement, a BBSA. And that we're not talking about the droid in Star Wars. This is the BBSA that is mandatory to be filled out by buyer brokers before you start offering brokerage services to your client. If it's not in the file, the firm cannot take any money from escrow and you won't get paid.
So when Jeff says the BBSA, of course, he's talking about Form 41, the Buyer Brokerage Services Agreement, that every broker has a state law obligation to enter with their buyer before the broker provides real estate brokerage services to the buyer, or as soon as reasonably practical after the broker commences the performance of real estate brokerage services for the buyer. A lot of words that mean one thing. You have to have that BBSA entered and signed by your buyer at the outset of your relationship, not the minute before they sign their purchase and sale agreement, and certainly not the minute after they sign their purchase and sale agreement. So, Jeff, have you actually heard of firms where the funds that would have otherwise been paid by escrow to the buyer brokerage have been rejected by the buyer brokerage because there was a missing BBSA?
I have heard that happening. It hasn't happened in my firm, but I have heard it happening, and then escrow has to figure out what to do with those funds.
That's right.
Because the brokerage can't take it because the brokerage cannot pay the agent.
That's right. And remember that in every buyer brokerage services agreement, the initial agent is the firm. And so if there's no BBSA, then the firm, an agent of the buyer, is the first, has violated the agency law right along with the buyer broker. And so Jeff is absolutely right. No compensation can be paid to the firm or the broker if there's no timely executed buyer brokerage services agreement in the transaction folder.
So brokers, make sure that you have that done right up front because you'd like to get paid in real estate.
That's right. Enter your BBSA timely, and please, please, please pay attention to paragraph 17B of the Form 21.
Perfect.
If you have questions on this topic or any other, visit warealtor.org and follow the links to ask a question of the hotline. Thank you for being a Washington REALTORS member.